Welcome to Vantage Point. Vantage Point is a discussion program in which we address issues of particular concern and interest to residents. I'm Marcia Boyles, and I'd like to introduce the two people sitting with me here at the table today. Kathleen Taylor, my co-host and co-producer.
Good morning.
Good morning to you, Kathleen. And our guest today, we're just delighted to have Paul Gonson. Paul is a fellow resident, a friend, was a practicing lawyer and a law professor before he came to Green Spring. Paul, we're so happy you're here today. Before we go any further here, I'd like to just stop for a moment and introduce the topic of the day. I think those of us who have been residents for some time here are very aware of the fact that the resident profile seems to have changed rather drastically, rather dramatically. Certainly there are contributing factors to this. There are several contributing factors. Certainly aging in place has got to be considered one of the factors in this changing profile. But we're becoming frailer. I think as a group we're certainly more challenged both cognitively and physically than this population was in the past. And so we're asking the question as residents. We're asking two questions, really. We're asking, have the standards for admission to independent living changed? And if they have changed, why? And who changed them? And who are the gatekeepers? Who are the gatekeepers in terms of applying admission standards? And of course, we turn to the social workers who do administer the tests. We all remember when we came in being given cognitive tests. We had to count back from 100, I think, by 7. And some folks say that they had to carry 10-pound bags of kitty litter around a table. So that's part of the, I think, at least the myth of Green Spring. Yeah. So Kathleen, let me turn this over to you.
So probably, I think the most intriguing question is, of course, who's the gatekeeper? And is social work the gatekeeper? Which makes me go, oh, no. No. I don't want that responsibility. That's a lot of responsibility. But I understand the residents have that perception because we are there at the very beginning with the pre-residency process, and we are the people who give you the tests that you feel you have to fail or pass and not fail to be able to get in. So we get associated with that gatekeeper role.
Yes.
So I think that that's really what we want to focus on today a little bit, as you know, where do these standards come from?
And have they changed?
Well, I think that first let's just talk about, you know, where they come from, because I think people are going to be really interested to know that the true gatekeeper for the standards for how people access housing services, and certainly senior housing and CCRCs such as Green Spring, are actually in federal law. I think that that people think we might be making these things up as we go in the community, but as there are several federal laws, which Paul is going to talk about, that impact standards of practice in CCRCs and other housing areas, as a community, our standards of practice, our policies, our procedures, all of that good stuff in terms of how people come into Green Spring and how people live in the community are following the rules. We strive to follow those rules and be compliant with those laws. That's what we have to be able to do and what we want to be able to do. So, since I'm not the legal expert, but I have anointed Paul as our Vantage Point legal expert.
And our pay is terrific.
Yes, absolutely. It would be great if you could talk a little bit about those laws and how they impact the CCRC in particular.
Our country has a national policy to enable persons with disabilities to participate fully in the social and economic life in the American Main Street. And as you said, this policy is implemented by federal laws, two laws in particular, the Federal Housing Act and the Americans with Disability Act. The Fair Housing Act is part of the Civil Rights Act and was amended in 1988 to prohibit discrimination in housing on the basis of handicap.
In housing.
In housing, that's correct. The Americans with Disability Act was signed into law in 1990, and it prohibits discrimination on the basis of disability in all activities of public organizations and in accommodations operated by private entities. Now, we all agree that these laws are more than a legal obligation, they're a moral imperative. Both of these laws apply, as you said, to continuing care resident retirement communities known as CCRCs, like Green Spring. And they apply at the time that a person applies for admission, at the time the person moves in, while the person is here, and as the person may move up from independent living to higher levels, such as assisted living or skilled nursing. The Fair Housing Act uses the term handicap, while the Americans with Disability Act uses the term disability. The courts have said that both terms are legally the same. Both statutes broadly define disability as individuals who have a physical or mental impairment that substantially limits one or more major life activities. Some examples of covered disabilities are ambulatory status, the ability to move around, dementia, blindness, heart disease, and arthritis. In addition, clinically accepted mental and addictive conditions such as depression and alcoholism also are within that definition. It does not include addiction to controlled substances. Both statutes require housing providers to make reasonable accommodations when such accommodations may be necessary to afford equal opportunity to use and enjoy a dwelling. If you treat persons with disability exactly the same as others, that may sometimes deny them an equal opportunity. The reasonable accommodation standard does not mean that the provider must do everything possible, humanly possible, to accommodate. It requires an inquiry not only into the benefits of the accommodation, but also into the costs as well.
Reasonable accommodation certainly could be a very, a very subjective kind of term, couldn't it?
It could, but there are some court cases, which I'll discuss, which have put some
This has been
flesh on it.
tested, okay.
That's right. But reasonable accommodation, as you pointed out, is a fact-intensive question, but it must be clearly disproportionate to the benefits as well as the costs that would be involved. Now, there's been litigation against CCR providers brought by residents and by the U.S. Department of Justice. And these cases illustrate what is prohibited and what constitutes a reasonable accommodation or an unreasonable request. Regarding admission to a CCRC, which I think is one of the key questions that we're interested in today, generally, pre-admission inquiries about an applicant's physical and mental abilities can be considered unlawful disability discrimination. CCRCs are prohibited from imposing a requirement that tenants be capable of independent living.
Now that's a really interesting statement. Say that again, Paul.
The CCRC,
In order to be accepted into independent living, they don't have to prove that they could live independently.
That's correct.
Wow.
That's correct.
There goes that being able to pick up a 10-pound bag of kitty litter,
There
right?
you go.
No more.
Yes.
No more.
Nor may the CCRCs ask questions about a disability or about the nature or severity of a disability. Courts have said that residents can have live-in aides in their apartments, even 24 hours a day, and that aides can assist residents in communal dining rooms. CCRCs may not separate persons with disabilities from the general population, like putting them in a separate building or putting them on separate floors. Scooters may not be prohibited outright, but restrictions to protect residents' safety are okay. In one case, a court upheld a CCR policy that prohibited securities in crowded lobby areas around mealtimes and which established routes for scooters to enter the dining room and even required residents to eat at tables near the exit. So that was part of the safety concerns dealing with scooters. In a federal case in Northern Virginia, a resident claimed to suffer from a, quote, multiple chemical sensitivity and required that the landlord, or requested that the landlord stop using a certain kind of paint and reduce the amount of cigarette smoke that escaped from a neighboring apartment. The court said that she was regarded as having a handicap and not accommodated, and the landlord was found to have discriminated. Several cases involving parking were recently decided. In one case, a resident claimed that he was disabled and that the community was, in order to give him a reasonable accommodation, was obligated to give him a free parking space. The court disagreed, saying his request to waive the parking fee was unreasonable. In another case, a resident claimed that she had been denied a reasonable accommodation when she was not allowed to park on the street was rejected by the court. So you can see that the courts will go both ways in this kind of evaluation. And I guess in answer to the question that you had raised, well, these laws have been on the books for a long time, so why is it that just recently there's been a change? And I think the answer probably is that due to recent litigation, there's become a greater awareness by CCRCs that these laws must be applied. And I think that the legal people in these communities have now told the admissions people that they should now take these into account.
Yeah, I mean, I think that's, like the question was, you know, why does it appear that these processes have been changed over time? That back in the day we were doing it one way, and now we're doing it a different way.
Back in the day, apparently we were sort of ignoring the law. I mean, and I'm assuming all CCRCs were doing that.
Yeah, well, I wouldn't say ignoring the law. I would say probably not aware of the law.
Not aware of it.
And I think there was kind of a period from just sort of some of the reading that I've done, it looks like the CCRCs were sort of under the radar. People didn't really know how to interpret CCRCs into the law. And I think that there was a lot of, people just being under the radar and maybe not on their own following the laws conscientiously as they might. But I think a lot of it was awareness. And so sort of to answer that question about things changing here, as Paul said, we are becoming more and more aware all the time of how our policies and procedures have to be in compliance with the law. And we want them to be, because again, as Paul said, that's not just a law, it's morally a right thing to do, to not discriminate against people because of disability. So those are things that as a community we want to uphold as well.
Kathleen, you certainly have contact with a number of other CCRCs, including those in the Erickson system. Is it your perception that all of the CCRCs now, in addition to the Erickson ones, really virtually all of them are being fairly careful about compliance with the law?
I'm actually really not in contact with any other CCRCs, but I mean,
outside of Erickson.
Erickson has, I think we have 17 or 18 now, and definitely it's an awareness that's across the board in terms of the Erickson communities, and I think that, as Paul said, as there's more litigation, as residents are testing, what their rights are, and they're going to court, then I think more and more is getting defined all the time in terms of that balance between the rights of the resident and the rights of the community. And that's a good thing, right? I mean, that's all we're trying to balance that out all the time.
It is a good thing. And when I was in private law practice, I used to advise clients that they should obey the law. And it was good for them to do that, not only as a moral matter, but it was good as a practical matter, because they would be more likely to keep out of trouble or have regulators come pouncing on them if they would obey the law.
Right.
But my understanding generally is that around the country, I'm not talking about the Erickson communities, there still are CCRCs that are not quite up to...
Not totally in compliance.
Not totally in compliance with the law. But I think over time they will all eventually have to be. Otherwise, there will be lawsuits against them.
Right. And lawsuits cost money, so
They
I mean,
do.
that's from a business standpoint.
That's right.
Not
And they're embarrassing.
that's a practical
That's right.
matter as well.
Now, let's talk about the practical aspects of this. When somebody now applies for admission to Green Spring, is part of the process still that the social worker does some testing? How is that working now?
It's definitely changing, and the testing is certainly not, that physical kind of testing that people went through 15 years ago or whatever.
Right.
I mean, that was when we were on a apparently very steep learning curve in terms of how we were interpreting the law in our procedures and policies. So we've continued to refine that process, and so I mean, there's not really anything physically.
Nobody's carrying kitty litter.
No, nobody's carrying kitty litter at all. And some of the questions about, we're definitely not, and this is also actually compliant with HIPAA regulations, that we're not, asking a lot of personal health care questions. Which a long time ago, I think we were probably asking a lot more specific questions about people's health care. And so there's nothing mandatory, because that would not be, again, in compliance with the law to be requesting these.
Are you giving
kinds of
cognitive tests?
information. We are offering.
All right, and does that simply provide a baseline for folks' records?
Well,
what's the purpose of that?
The purpose is actually we offer that to people. We have our memory support continuum here on campus, where we do provide a lot of services related to memory health, brain health. That we, I think a lot of residents coming in, potential residents coming in, that's something that they're thinking about. How do I stay as active and cognitively active as possible? So we do have a lot of resources on campus. So when we talk about doing that assessment, basically what we're talking about is, would you like the opportunity to see sort of, how you're doing, and then we can sort of offer these different resources.
This is a standard test?
This is a standard. It's called a MOCA. It's a Montreal Cognitive Assessment test. I will say assessment, because test always feels like, I'm gonna fail.
Right.
So we're offering, but there's no, people do not have to have it. It's going to be a matter of personal preference, whether they would like to have that information or not.
All right, so then the basis really of discussion about physical and/or mental capability is primarily so that you can talk about the services that Green Spring provides.
Exactly right.
Okay.
Exactly right.
right.
Perfect.
All right, and that makes sense. I mean, we have to remember, Kathleen, that as all of us need to be reminded that that's really what social workers, that's one of their main functions here, is to provide help and information about services.
Right, and that's the goal of the campus too, is from a continuum of care standpoint. That's why we have all these services that, as people change, as people age in place,
right,
that they are aware of and know that they have access to all these different beneficial resources across the continuum. So that's always what we're talking about with the residents. When they come through the door, I think that that's in part what they're thinking about is,
right,
I'm here now,
what are the
but
benefits?
at another point, I might need something, so it'll be great to have it here. I don't have to go anywhere else.
Yeah. Yeah, that absolutely makes sense, and certainly that's one of the advantages to moving into a CCRC,
That's right.
as you're pointing out. And Green Spring, I think, just does it probably as well as any CCRC in terms of the services that are provided.
Absolutely.
The broad range of services. Do you think that this perception of changing standards is very well understood? Paul, do you have any sense?
I don't think it is well understood yet. It's interesting. This is, of course, a non-legal, unscientific statement I'm about to make. But if you go to the dining rooms and you sit around this table with 6 or 7 other people, you hear people say, gee, they're letting everybody in now. In other words, the notion is that many people who came in, as I did a number of years ago and went through a rigorous pre-screening, say, here are people coming in with scooters and walkers and so on. Mm-hmm. And a lot of these people seem to divide in their mind between people who have been here, maybe people they know well, and as you point out, who have aged in place and now have a mobility device, and that seems acceptable. Maybe these people are facing their own future and seeing that they may themselves be in that. But for brand new people coming in, they seem to have a different point of view. And I think it's useful to have this program to sort of explain, not so much what has changed, what has always been the case, but rather what our community and other communities are now beginning to realize is the law and applying it in a fair way.
This certainly changes the complexion of any community. Kathleen, can you speak to that in a sort of general way? What you are saying in terms of the change in the demographic here?
Say more.
Clearly, we're requiring more services. I think the whole issue of socialization changes somewhat with disability, when the percentage of those of us with disabilities rises. I think neighborliness is affected in some ways, and that's a kind of an odd term, but communication perhaps, socialization, I think all of those things are impacted. There's a different feel, quote unquote, to Green Spring.
Yeah. Well, I think there's, we talk about diversity sometimes, and we don't feel like we have diversity in some ways, but I think we do have diversity in ways related to how people are aging in place, the different types of disabilities that people might have in the community, and how we react to that as a community, how we respond. Are we tolerant?
I think we don't normally think of this as a diversity issue, but you're absolutely right. Of course, it's a diversity issue, and it's a civil rights issue, in the same way that color or race or whatever.
Yeah.
Have you thought of that as a diversity issue?
Yes, I think it is a diversity issue, and I think that fair-minded people who think about it would say this is a good thing. It's not a bad thing, and people will, as they do with other things, will get used to it.
Right.
And that's very good.
Right. But I guess, the residents are on a learning curve, too, in terms of these changes.
That's right.
And trying to sort them out and understand and make sense of it. And I think that understanding the legal underpinnings of some of this will maybe help put it in a perspective, too, that it's not, again, it's not arbitrary or capricious. There's really a lot of intention to it. And it's grounded in, not discriminating.
In fairness.
In fairness and equality and all of those good things that we all believe in. It's hard. I think the balancing of the rights of an individual with the rights of the greater good is a tough one. It might be the toughest one that exists, and we're a little
Absolutely.
we're a little microcosm of the world, and the world's struggling mightily. So I think that it makes sense that we're struggling too.
Yes, I think it does, and you're absolutely right. I mean, I think we are learning to accept this. I think here, the fact that the community has changed, and I do think you put your finger right on the issue, which was it felt arbitrary, or it felt as though it were possibly arbitrary, that new standards had been imposed. We didn't know whether we simply had willful social workers.
Oh no,
No,
never that.
I am teasing you
But
here.
I think that people were questioning the agenda. What was driving these changes?
Right.
And what we're saying, hopefully, pretty clearly is that these laws have been in effect for a long time, but as the housing, the whole housing arena, and certainly senior housing and certainly CCRCs, we're figuring out how to implement them. And some of that has been helped along by litigation that's occurred in other communities where, as Paul said, these rulings have been fleshed out so that we know actually how to turn them into policies and procedures that are affecting real people.
That this is an industry-wide issue.
Absolutely, yeah.
Not just a Green Spring issue. And I think that was the thing that people had not been aware of, that it was an industry-wide, CCRC-wide issue. Well, I think this has been enormously helpful. Paul, anything you'd like to leave us with here?
Just maybe a question for Kathleen. When you interview people, do you make some sort of assessment as to whether they would be acceptable in independent living, or they should go into a higher level?
We, as Marcia was saying, the assessment is in terms of what services would be most of benefit for that person. Mm-hmm. So if someone would appear to be a better fit in a more structured, supported level of care, then we would make that recommendation for sure.
As offered by Garden Ridge.
Yeah, yeah. I mean, we would definitely, as a professional, we would definitely want to say that what we know about independent living, for example, is that it's a huge environment. It's huge. I get lost.
It's a very big place, isn't it? With 2,000 people
Yeah,
here.
it's very
spread
big, spread out. Getting to the dining room sometimes can be, depending on where your apartment is, if you are mobility challenged, have other kinds of concerns, that could just be your whole day, trying to get back and forth to the dining room. Doesn't leave
And
you any...
mail and
Yeah,
cubby
all of those
and-
things. So may not leave you the energy to do all of the things that are more fun that we would want people to do. So those are the kinds of ways that we would present it to somebody, just to help people assess the environment in terms of pros and cons for different settings.
Is safety issue also?
Yeah, definitely we would have people thinking about all these things. I mean, what we're looking for is an informed decision based on as much information as we can give that person. That's the goal.
And I guess the point is being helpful to the person. In other words, not trying to separate them out or discriminate, but trying to be affirmatively and positively helpful.
Right, and ultimately it is that person's choice. We're not saying, no, you are not allowed. I mean, there may be actually situations that are beyond the Fair Housing Act that would,
That are so extreme.
possibly, impact that decision. But in general, it's, just going to be helping the person to see the benefits of a particular service, and how that fits with what their preferences are.
That was a good question, Paul.
It's a great question. Hard question.
Exactly. So really, basically, the only two criteria that can be applied in terms of admission, discrimination, are financial issues and age, 62.
Yep, those
So
are the two.
those are it.
So I guess the 62 makes us the senior housing, and then whatever the financial is.
Yes, and the financial, of course, is a major thing. Well, folks, I see that our time is coming to an end here.
Wow.
Anything that anybody wants to follow up with?
No, I think it's a very useful program, and I hope residents will take it to heart.
Yeah, I do too.
And I think we would like to consider exploring some of the ramifications of all of this at some point too, Kathleen, on Vantage Point. So any comments and questions and concerns that folks have about this, I hope they will share them with any one of the three of us.
Yeah, absolutely.
Oh.
Yeah, I think this is another program in the making.
Yeah, I do too. And this, I agree with Paul. I think this is a major dinner time conversation.
Yeah, and that's what we're always looking for, is to stimulate conversation. So hopefully that's what we did.
Good.
Well, terrific.
So I guess it's time for our announcements.